matter of case number CFI-009-2023 and CFI-005-2016 and is being held by way of video conference before Justice Sir Jeremy Cooke, appearing on the case. Any orders made during the course or at the conclusion of this hearing will be made on the judge's instructions by the registry in Dubai. The claimants are represented by HFW Middle East. Lead counsel is Mr. Sharif Shifji, KC. The first and third defendants are represented by Jones Day. Lead counsel is Ms. Heather Martin. Will the judge and the representatives please confirm that the situation is as I have stated?
Confirmed, thank you.
That's confirmed.
My apologies, Justice Cooke. Could I just raise that we're getting a terrible echo? Is anybody else getting that?
I believe it's only from your end, Ms. Martin.
Could I have 2 minutes with my IT tech? Because I'm not sure that I can even really understand what anyone else is saying with this echo.
Okay. Right, Ms. Martin, are you all set?
I can now hear the hearing. One of my colleagues is still getting an echo. So, it's resolved. Thank you very much. Thank you for the court's indulgence.
Right. Well, it's I don't know what order you and Mr. Shivji are planning to deal with things. You each have an application, obviously.
My suggestion would be for my client to go first on the extension of time, as we did last time, on the basis that logically that is the first point that needs to be resolved. But of course, my learned friend wants to suggest a different sequence. We can hear from her.
That's fine with us.
Well, there's a fundamental question, which is whether we're going to sit here and seriously go through the same arguments as we had on a previous occasion, which I'm not in favour of. But let me hear from the parties as to what they were thinking of doing.
I'm grateful. That is, as you would expect, a point I wanted to address you on. What I was proposing to do was to make some preliminary points about the involvement of the first to third defendants, and then to address you on essentially the new points on the extension of time. And I will then address you in due course on the question of whether the first and third defendants can revisit arguments that have already been pursued before your lordship and which they were unsuccessful. But if I may, I'll come to that in due course. I don't intend to duplicate what I've said before, and I'm not going to set out in detail the points made in my written submissions, because I know your lordship will have those on board already. But if I may, I can hopefully launch quite quickly into the extension of time, deal with that swiftly.
I think there's a lot of point in that. The only question is whether there's anything new that makes any difference.
There are a few new points that they don't help the defendants, but they're points I'd like to draw to your attention.
I've got the points about the powers of attorney and all that sort of stuff. But, my inclination is simply to hear from Miss Martin as to what difference she says any of the new material makes. As I see it at present, Miss Martin, and it's a matter for you to address me on, there's additional factual material that you put before the court as to where various activities occurred, which might impact on the jurisdiction of the Geneva court. But none of it seems to me really to go to the point as to which is the more appropriate forum, even if the Geneva court does have jurisdiction in relation to the tort claim, or possibly even the breach of duties claim as a director. It has no jurisdiction in relation to the insolvency claims. And as the claim is going to go ahead in any event against the fourth and fifth defendants in the DIFC, as matters currently stand, then you have a very uphill struggle to persuade me that Geneva could possibly be a more appropriate forum. So really, Ms. Martin, I think I'd like to hear from you as to how you propose to put the case and what difference any of the new material makes.
On the new material, on the forum nonconvenience argument, Your Honor, we think that it goes to a question that was pretty significantly debated during the last hearing, and that is whether the Geneva courts are an available forum.
But even assume that. Let's just assume that for the sake of argument.
Okay.
How does it make it? How does it make it more appropriate?
Well, it makes it more appropriate because it adds additional bulk, if you will, to the evidence suggesting that all of the actions were undertaken from Switzerland in their capacity as employees of a Swiss bank as part of the corporate governance structure of actually a higher holding company. And that to the extent these actions are alleged, or there aren't, let me take a step back. It's not that there are so many alleged actions, it's that there are alleged omissions. And where do these omissions take place? They take place in the defendant's capacities as employees of the Swiss bank. They simply couldn't have done the things that Mr. Shiji says they should have done, or that the consolidated particular claim says that they should have done. And I think it's important to go through the new evidence and the new authorities as to what the corporate governance structure actually was, to say that the Swiss courts are clearly the more appropriate forum.
But the whole basis of the claim is put against you as breach of your duties, your client's duties, as directors and employees of the first claimant, and now in their capacity as directors or employees, to the extent that they are, of the fifth defendant. I mean, the fact that in order to wind up the company and in order to do certain things like take on board clients for banking purposes, you have to do things in Switzerland, is nothing to the point of the claim that's made against you, which is very specifically for breaches of duty in relation to the position, their position as directors, employees of the first claimant. So I just don't understand how the point really helps you.
Well, if I could be more specific, Your Honor, as I understand the gravamen of the claim against the directors, and by directors I mean Mr. Sassoon and Mr. Astruc, because Mr. Carton was separately situated, but the claims against them are that they should have sold BSA or sold its assets, I guess, as I understand their claims. They just simply didn't have the authority to do so. All of those activities only could have rested at the Swiss bank, and actually not even the bank itself, at JSS Holding Company, the corporate level sitting above it. So whether or not they should have done that is really an allegation of what their role was within their employment in those organizations.
But isn't that missing the whole point as to what is alleged to have taken place in the dealing with the relationship managers and taking them out of the claimant company and putting them into the fifth defendant, and thereby taking all the clients with them in order that they should sign up with the various banking facilities and so on that were being offered from Switzerland, Hong Kong, Singapore, and everywhere else?
Well, I read the court's last order to hold that. We read the consolidated particulars of claims somewhat differently, and I think it's actually important to talk about what the roles of these people were. So if we're talking about Mr. Sassoon, he was not a director at the time that the RMs are alleged, or RMs being the relationship managers, were alleged to have been induced away from BSA. He simply no longer had a role with BSA at that time. I don't think it's actually even alleged that he had any direct contact with the relationship managers. I'd have to go back and refresh myself on that, but certainly no correspondence or any other concrete communications have been put in suggesting that he induced anyone to do anything when it goes to recruitment at the fifth defendant. Those recruiting activities were undertaken by employees of the fifth defendant. Now, Mr. Astruc is Group General Counsel. He doesn't involve himself in such commercial matters. He's the head of the legal department, and is certainly not involved in relationship manager recruiting at even Swiss, but certainly non-Swiss joint ventures or wholly owned asset management companies. It's just not part of what he does. He very rarely gets involved as a director of any company, and really only when it has thorny legal issues that require his expertise. So the idea that he was contacting RMs and inducing them to move to the fifth defendant is really quite foreign to us. And again, we don't read the consolidated particulars of claim to allege that. Now, as to Mr. Carton, he just didn't have a role at the fifth defendant at that time. His only role at a subsidiary of the bank was at VSA. There was nothing for him to induce them. He was trying to wind down the company in an orderly way, as he had been directed to do by the shareholders in their wind-up vote. I would further bring to the court's attention, and this is well known to the claimants, that the things that the court is concerned about are things that ACCL did under Mr. Walia's watch. And they did them during a time when Mr. Walia was a director, both of BSA and of his Alpen entities. And it's both troubling and just curious to us that these directors in their roles are being alleged to have done the things that are clearly documented that Mr. Walia did. Again, during a time that he held two arguably conflicting board director positions.
Well, all of that goes to the substance of the dispute, of course, which plainly I can't deal with at this stage.
Sure.
You know, I understand there may be all sorts of good defences and so on and so forth. What I'm looking at is the nature of the claim as put, and I mean, one only has to go to the summary of the consolidated particulars of claim to see the manner in which the claim is framed, which I think, if I remember rightly, I quoted in the reasons I gave last time. You know, that's what you have to grapple with. I'm looking at paragraph 5 and 6 and 7 and 8 and 9, 5 to 9 of the summary. And unless you're going to tell me that that is not an accurate summary of the way the claim is framed, however bad you say the claim is, it seems to me that that's the basis upon which I have to proceed.
Could I have a minute
Yeah,
with the summary?
Yes. Summary of consolidated particulars of claim. I think it's at is it A76 or thereabouts?
Do you happen to have a page number, or do the claimants have a page number in the bundle?
Yes, that's page 75.
Yeah, 75, not 76.
Thank you.
75, well, it is 76, in fact, if you're looking at the relevant bit for these purposes, which is, I'm focusing for the moment on paragraphs 5 through to 9 of the summary.
So as to paragraph 5, what I would say is this is intentional passive voice blurring of lines to obfuscate who is doing what. I don't think it's controversial that the fifth defendant hired relationship managers who had previously been employed by by the first claimant. But
Yeah.
that was the prerogative of their hiring team who was independent, who they hired from Bank of Singapore. So I keep going.
Yeah, well, that's going to the merits again. You see, it's not going to the nature of the claim that's put.
Sure, but if I can, just quickly address the actions of the individuals, because I think that's what we're concerned about here today.
Well, paragraph 8.1 is probably what 8.1 and 8.2, and in particular, Mr. Sassoon is dishonest assistance in the fraudulent breaches of duty. And 8.4 is unlawful conspiracy involving all of the defendants, both the individual defendants and the fourth and fifth.
Certainly, Your Honor, and I do read those as the causes of action, but it still is query what the activities of the individuals are that are alleged to have led to those causes of action.
Mm-hmm.
Respectfully, Your Honor, we, as I've stated, just don't have the same reading of what is being alleged. What we read being alleged in terms of what concerns the individuals is that they allegedly should have sold the business. And I actually think that that's a quote that the claimants used in their skeleton. And it said in contending that they didn't need to have the power to do so, they said they didn't need to complete a sale, they needed to procure a sale. I'm actually quite curious from Mr. Shivji what that means in circumstances where they didn't have the power and their shareholders board that controlled the entity had voted to wind it up during that period. What were they supposed to do? Rebel against the shareholders board? I actually don't understand the allegation on that basis, but we did our best job, or the best we could do, to put in evidence of the relevant actions and omissions, to the extent you can evidence that, of the individuals at the relevant time.
Well, take me to the bits of the consolidated particulars of claim that you rely on.
That I rely on?
Yes, as to what you say the claim is. I know what you say as to how you say the claim ought to be framed. But what I'm looking at is the way the claim is framed.
Yes, Your Honor, just a moment.
That's not the skeleton that you just referred to.
We are looking for the specific allegations in the consolidated particulars of claim, Your Honor, but I would direct the court's attention to the skeleton reference that I just made. That's on page 6740.
I'm so sorry, give me that reference again.
6740. Oh, so sorry, 6179.
And what is that that you're directing me to for the moment?
So I'm directing you to claimant's second skeleton.
Right. Let me just find that.
And specifically paragraph 43.3.
Yeah.
So the first through third defendant rely on the allegation that they failed to procure the BSA, market and or sell its business for value, and instead seeking the liquidation of BSA without a sell, which they state was something that only the board of the group's holding company could approve, making it a shareholder matter. This is but one of many allegations of breach of duty set out in the consolidated particulars of claim. However, the nature of the allegations is not that they failed to complete a sale of the business, but that they failed to procure such a sale. The claimant's case is that the defendant stood back and allowed the raid on BSA's business instead. So again, it's an omissions case.
It's two things, isn't it? It's they actively took part in decisions to make that happen. Whether you put it as acts or omissions is really neither here nor there. Of course, they couldn't in themselves complete a sale of the business, and the shareholders had to be involved in winding up and so on and so forth. But where you've got directors who allegedly act in breach of their duties as directors of the company in allowing its business to be taken away from it and given away, and that's the nature of the case that's being made against you. Maybe right, maybe wrong. Maybe that everybody was agreed on it. Maybe Mr. Al-Wali and all the rest of them are equally at fault. Maybe the whole thing was, quite deliberate as a way of trying to defraud the Alcaralfes who are about to get a judgment.
On that point, Your Honor, the actual evidence and I'm sorry to interrupt, but the actual evidence that's before the court is not that that's the case. The actual evidence before the court is that essentially as soon as the Soffer family bought a Sarasin Bank and did their post-acquisition due diligence, they came to understand that they were not in business with someone that they wanted to be in business with in 2012. They took legal advice.
I understand all of that. I understand the factual background. I understand the factual disputes. But what the liquidator is looking at is a company that had an active business that was given away in order to deprive, as it would appear, the Alcaralfes of the value of their judgment. That's the essential point. And again, he may be right, he may be wrong, but that's absolutely the essence of the claim. And you may be right in saying, well, these aren't the only people who are responsible for it. So too was Mr. Al-Wali and the other side of the scale.
Well, just to clarify what I'm saying on that point, our point is not, well, they're more guilty than we are of these fraudulent acts. My point is most certainly that we deny any fraudulent acts, but if the claimants believe their own case, they most certainly should have brought allegations against Mr. Walia. Otherwise, we find their belief in their case to be insincere.
Well, yes, I see. Well, that's an unusual submission to make in the context of jurisdictional issues, that they ought to be joining other people as well. But there it is.
It's a rhetorical point, Your Honor. It's certainly not a primary argument when it comes to jurisdiction.
You know, what we're getting into here is the merits. And I'm in no position to grapple with the merits of this at all. But what I have to proceed on is the way the case is put, the nature of the claim, and where is the best place for that to be heard.
I understand that, Your Honor.
Anyway, Ms. Martin, don't let me stop you. You know exactly what my thinking is, because you've seen it in my previous reasons. And the question really to me is what can you rely on that is really going to make any difference to the view that I'd already formed last time, and why should it be any different this time?
Your Honor just simply has a lot more evidence in front of the court about locations of the individual defendants, where they were when various decisions were taken, and in what capacity. And including, we had a debate on board meetings, and I believe that the court previously found that it didn't find sufficient evidence that board meetings were taking place in Switzerland, or that a majority of them were. The evidence now before the court is clear that the deemed location of the vast majority of board meetings in which any of the individual defendants was involved was in Switzerland, that the vast majority of attendance was actually from Switzerland. The court has their travel records to show very scant travel activities to the region. None of this has been rebutted by the claimants.
Well, let's assume that's right. Then where you say that goes is to show that, in fact, the Geneva court does have jurisdiction because of acts which took place within its territory in relation to the tort claim, right?
Both in relation to the tort claim and in relation to the director liability claims. If this is not administration by directors from another jurisdiction, then I think that becomes
all right. Well, let's just assume all of that for the sake of argument.
Sure.
How is that going to help at the end of the day when the insolvency claim in particular is going to go ahead, can only go ahead, under the DIFC insolvency law with a DIFC appointed liquidator in a DIFC company, bound to go ahead in the DIFC, isn't it? I mean, I don't see any answer to that point for the moment. If you've got one, please give it to me.
Well, the evidence from both Swiss law experts is that it can go forward in Switzerland as well after a relatively perfunctory recognition proceeding. Those claims are also available in Switzerland.
Well, all right, I hear what you say.
As to Mr. Carton, I don't want to leave him out because I realize that he's separately situated. I think the court previously found that he lived in the DIFC. That's not the case. I wanted to make sure that the record was clear there. I think that the court also might have found, or I may be confusing this with one of claimant's arguments, that the so-called 2013 relaunch email was drafted and or sent from the DIFC. That is not the case. As evidence is that he was not in the DIFC when that email was constructed. All of the information that is baked into that email, again, there are claims that that is BSA's confidential information. Now, the evidence before the court now is that that is actually the confidential information of the fourth defendant, which is hosted on servers in Switzerland and made available to people who need to see it by a Swiss banking software solution called Avaloq, and that it was only available to Mr. Carton in Dubai or the DIFC or wherever he was through the system. But again, the confidential information belongs to the fourth defendant and sits in Switzerland. And his ability to share this information back with the Swiss bank is confirmed in his DIFC employment contract with the fifth defendant. Oh, sorry, not with the fifth defendant, with the first claimant, in which it makes clear that even assuming that confidential information belonged to BSA at the time, which our position is that it didn't, but even assuming that it did, he was fully authorized to share any confidential information with the fourth defendant and any companies under common control. Now, again, that gets a little bit into the merits, but talking about who was where and where this information lived and all the various geographical factors that we say go into what is clearly the most appropriate forum, I wanted to make sure that they were clear before the court and that the court's judgment is accurate in that regard. Would the court like me to take any of those documents, or?
Well, I don't want to stop you in any way, Ms. Martin. I'm well aware that you're seeking to appeal the last judgment, and if I make a similar finding, you will doubtless seek to appeal this, and that's where we are. The real question is whether anything else that you've produced that's new makes a difference to what the views I already formed. I'm looking back, I see no reason to revisit my decision of last time, and I'm bound, I think, to come to the same conclusion. And there's something which distinguishes these defendants' positions. And the other particular difficulty you've got is that in the case of one of the individual defendants, he's got an exclusive jurisdiction clause in his contract in favour of the DIFC. On the face of it, he's stuck with that, and unless there's very strong reason why he shouldn't be held to it, he's going to have the claim going against him here. So you finish up with three defendants who are having claims going pursued against them in the DIFC. It's obviously sensible for all claims against all defendants to be in the same place. Added to which you've got the insolvency law point that we've discussed. And it seems to me that even if the Swiss court does have jurisdiction in relation to the tort claims and the fiduciary duty claims and so on, it just doesn't get you home. So if you want to say anything more about that, please do. As I say, I don't want to stop you in any way. I want you to have every chance to say what you need to say.
Well, I recognize that the court was not persuaded by the Liz Pendens point last time, but I do think it is a very important factor, and including yourself, Your Honor, you have recognized in the past that the potential for inconsistent outcomes is a very persuasive factor. We would suggest it's a very persuasive factor here, especially because Liz Pendens is a statutory matter in Switzerland. And so the Swiss resident defendants in particular, and we would suggest Mr. Carton, who is a Swiss resident defendant, but also the fifth defendant, have a statutory right to have the courts recognize that those proceedings involve the same parties and the same issues and were pending first.
Yes.
As I said, we were mostly relying on the new evidence on behalf of the individuals, which was only put in after our last hearing. And
Yes. All right. Do you want to say anything about the extension of time that's being sought? Again, at present, as I see it, it's much the same point as last time, but are there any additional points you want to make that help you as opposed to those which Mr. Chivkaji wants to say, which he says help him?
well, Your Honor, I would ask the court to focus on the legal standard. We recognize that paragraph 12 of the order with reasons from last time states that whatever the claimant's initial delay in instituting the steps required for service on the fourth defendant in Switzerland, it would be wholly unjust not to extend time for service in circumstances where the defendants have been deliberately uncooperative and declining to accept service by other means than through diplomatic judicial channels, which are known to be dilatory. Respectfully, that's not a recitation of the standard by which extension of time cases are judged according to the cases. They require the claimants to put forward and evidence good reasons. We didn't see a finding of good reasons in the court's prior order. We've not really seen any evidence from claimants. They had statements in a solicitor's witness statement, but we put forward numerous cases that say that that's not enough. They have to evidence it. And not only do they have to evidence the steps taken, they need to evidence the reasons why the delay is reasonable. They haven't even endeavored to do any of that. What they basically say is that there were these sometimes 2 weeks, sometimes 1 month gaps between steps taken, which all sum told resulted in a 4-month delay in them initiating service by diplomatic means. Now, the diplomatic service was effected in 2 months, so if they had undertaken their steps timely, it would have been in time and there would have been no need for this application. We simply don't see a basis in the law for the burden shifting that the claimants are asking the court to undertake and say, well, really, it's all the defendant's fault because they didn't scramble at the last minute after receiving very nondescript summons from the Geneva court. I'm actually happy to take the court to those summons if it wants to take a look at them. Summons from the court that have no identifying information on them whatsoever, that just says you are invited to come to the court by the 10th of August. So sometime after that, claimant solicitors write to the defendants and ask them to pick up the summons by the 1st of August, which is a public holiday. They left them less than a week to try and take these steps. Europe is known for its aggressive vacation schedules during this time. The defendants did everything they were required to do under Swiss law, assuming they had any obligations whatsoever. There simply isn't any case citation by the claimants that it's an appropriate basis to find good reasons for their own delay to shift the burden to a 1-week period of time in which they say the defendant should have acted. Claimants have the burden here, and they simply haven't put forward the evidence or even the reasons why to demonstrate that delay.
Okay, thank you. Anything else?
I would like to address the Liz Pendens point. I know the court is not minded to find it as a standalone doctrine, but if the court is interested, at least at all in legal history, it's quite an interesting journey, I think, if it doesn't mind.
Well, I don't see how it helps because the DIFC law has been expressed in the Poitevin case, hasn't it?
It has, but if you look at the history of both forum nonconvenience and Lizelle by Pendens as a standalone doctrine in English courts, which it was for quite a while, you see that it has always been evolving over time to meet the moment, which I personally consider to be the majesty of the common laws, that's what it does.
Well,
and
I'm very familiar with this. I'm starting with the Aberdeen, Davos, and McShannon and Rockwell and the Atlantic Star. You know, I was involved in a number of those cases
I'm sure.
when I was at the bar. But you know, the position here is now pretty clear, it seems to me, and I don't really see how going through the past history is going to help. It's DIFC law we're concerned with, and DIFC law alone,
And we read the Horizon case as at least, as I believe it's Justice Giles, leaving an opening saying that there was more that needed to be said about lis pendens and forum nonconveniens and how they fit together in the DIFC. Now, if the court is not minded to take that as an invitation to explore that gap, we understand. We've taken it up with the Court of Appeals, and I'm sure they'll give us all some guidance. But that is what we would invite the court to do in this circumstance, is recognize that the Spiliota test in English law was adopted at a very specific time in the history of England and English courts. And that in parallel, at the same time, the Brussels Convention came into force there. And so lis pendens was actually at that time still being run in parallel to forum nonconveniens. It's really only in the last 2 years that forum nonconveniens subsumed all of these decisions in English court. And because the English court sort of genesis has been a recognition of the sort of past, and forgive the language, but this is from Atlantic Star, but the chauvinism of the system in believing that all disputes should be able to be brought in England and Wales, and recognizing that as a matter of international comedy, the courts needed to respect the jurisdiction of other courts. That is how Spiliota developed at the time. It was, as your court or your honor is obviously quite familiar, it was a pretty lofty undertaking by Lord Gough to get it across the line, which started with his advocacy in Atlantic Star, which was an entire failure. So to say that there's no room in the DIFC court, which is by its very character and by its very judicial values, an international court here for the purpose of inviting foreign investment in Dubai, that should not take a step back and decide whether or not it should be a little more cognizant of international comedy than the English courts are even now, just because their evolution on the issue has been a little slower. I think it would be a mistake for the court to do that.
What's your submission? That the place where proceedings are started first simply predominate, full stop?
Not always, but certainly I think that it can be a narrower holding than that. I think narrower is generally better. And here we would say that because the proceedings were issued first in Switzerland, and Switzerland has a statutory base for lis pendens, and it is the same parties, and it's the same issues under consideration, that the court should consider lis pendens to be a basis on which to stay proceedings here, at least until the Swiss courts decide their own jurisdiction.
Well, that's you know, that's going to conventions and treaties and so on that are not relevant for current purposes. Anyway, I know what the argument is. If that's an argument you want to pursue, then you're going to have to pursue it in the Court of Appeal if they let you.
That's well understood, Your Honor. I guess just as a last matter, I wanted to take up this allegation of Henderson abuse on the part of the claimants.
Yeah, I'm not very interested in that, to be frank, Miss Martin. It doesn't seem to me that point goes anywhere. You're entitled to make points on behalf of different defendants, and it doesn't seem to me that really assists Mr. Shivji. So unless he wants to persist with it and try and persuade me there's something in it, I don't need you to deal with it.
Thank you, Your Honor.
My lord, on that point, there are some submissions I want to make, so it might be better for Miss Martin to hear from me first, and then.
Yeah, well, all right, if you insist, but it doesn't seem to me that it's a very good point. Henderson is dealing with a point that someone ought to take when they have the opportunity. Now, you can say these defendants could have turned up on the last occasion had they wanted to, but they were entitled to wait until they were served and take whatever points they wanted. And it can't be said just because they're represented by the same lawyers that that they're stuck with with the arguments that were put last time. Anyway, Ms. Martin, if there's nothing else you want to say for the moment, I'll give you an opportunity to respond to anything new that comes up from Mr. Shivji that you haven't had a chance to deal with.
Thank you, Your Honor. I think that's appropriate.
So I'll listen to what Mr. Shivji has to say. I mean, it's pretty obvious, Mr. Shivji, what my thinking is from my reasons last time. So there's not much point in going through all that again. I don't think there's any purpose served in you addressing me on the lis alibi pendens point. It seems to me that the law in the DIFC is relatively clear as matters stand, and that one's interested in forum conveniens. So the only points I really want you to deal with are anything that you think you need to say in relation to what the new evidence does and any difference that that makes.
I'm grateful for that. For
Same
those
point
indications.
talking about.
Yes, no, I'm grateful for that indication, my lord. I certainly don't intend to rehearse what I said last time. That goes into the record as still my position. I'll only deal with the new points. I hear what your lordship says about abuse, but on something like abuse, your lordship, as a very experienced judge, will have your own view as to what is within the realms of acceptability and what is not. And I'm not trying to shift that view, but what I would like to do is give you some additional facts, which I don't think have necessarily come out sufficiently from the documents, which you can just take into account in assessing why we are here today. And I think they are important points. So if your lordship would indulge me just for a few minutes to hear out some of these points, then your lordship can take a view as to whether or not that shifts the dial. I had 4 points that I wanted to make about the first to third defendants and their participation in these proceedings. The first point was the date that those defendants retained Jones Day in this matter. And if your lordship goes back to the transcript from the last hearing at page 5486 of the bundle, does your lordship have that?
I'm afraid it always takes time, I'm afraid.
Yeah, I'm sorry. Apologies.
Yeah.
This is the transcript of the hearing on the 7th of September, and towards the bottom of the page, Miss Martin makes some submissions about when Jones Day were retained by D1 to D3, and she says there in the second sentence of the penultimate paragraph, Jones Day was only retained by those individuals on the 5th of September. We really have not had access to information from them for very long at all. And as we understood the submission, that reference to them not having access to them for information for very long at all was a reference to the 5th of September. Now, since then, after some pressure, Jones Day have revealed more information about their retainer by the first to third defendants, and they've produced their engagement letter, and that is in the bundle at 5145.
I believe we've produced those voluntarily.
Does your lordship have that? That's page 5145.
Yeah.
This is
10th of August letter. Yeah.
10th of August. There are 3 letters in identical form addressed to each of the 3 individual defendants. They're all in the bundle. I'm only going to take you through one of them. Looking at the terms of this letter, we also think that there is likely to have been the same letter sent to the 5th defendant, and we've asked Jones Day to confirm that. We haven't yet heard back from them, but anyway, I'll come back to that point. This is certainly the retainer letter for the 3 defendants. And if you
I
look
could
at the
just-
first
if I could just add,
sentence,
this was actually submitted by us in,
Documents, but we told them when we did what on
we submitted in Mr. Devenish's 6th witness statement when we did what, including our first contact with the individual defendant. So I don't think that it's controversial.
so my lord,
Paragraph 34. Sorry.
my lord, just looking at the first sentence of that, it says, "Thank you for retaining Jones Day."
Yeah.
The first sentence of the first page on the 10th of August. So it's clear that Jones Day thought on the 10th of August that they were being retained and that they wrote to the client thanking them for retaining them. And then
I would say that's not clear at all. This is standard language from our engagement letter that we send out to potential clients who may sign them or may not. This is quite standard fare.
My lord, I'm not finding it particularly helpful to have these interventions from my learned friend. She will get her turn, but if she would be kind enough to let me finish my submissions, this will go more quickly. If we then move to the 3rd paragraph of that letter, the 2nd paragraph of that letter, it says, "You have asked us to represent you jointly in our pre-existing representation of Bank Sarasin." So again, it's clear from that letter on the 10th of August that the 3 individuals had already asked them by that date to represent them in the proceedings. And then as is common with engagement letters, it required, the end of the letter required the letter to be signed and returned. And that we don't know quite when that happened, but the date on the letters is the 5th of September, and the evidence from Mr. Devenish is that they were returned on the 5th of September. And I do want to address you later on the 3rd defendant post-dating documents. So I'm not accepting that as the date, but that doesn't really matter for these purposes. So that's when the engagement letter was sent. Then my learned friend mentioned Mr. Devenish's evidence, his 6th witness statement, which explained what happened after the engagement letters were sent. And we can find that in the bundle at 4860.
Yeah, which paragraph?
Paragraph 34. And it first 2 sentences, he identifies the engagement letters and says they were signed and returned on the 5th of September. He then says in the 3rd sentence, without waiving privilege, on the 28th of August, Jones Day held its first meeting with the 1st and 2nd defendants in respect of these proceedings. Now that might be an important qualification. And he also says held its first meeting with the 3rd defendant to discuss his representation in this case on the 31st of August. And then he says, "I confirm that prior to these dates, Jones Day had not been instructed by the individual defendants in relation to representing them in these proceedings." Now, it's not entirely clear what these dates means, whether he's referring to those meetings on the 28th and 31st of August, or whether he's referring to the engagement letter on the 10th of August. But we say the better analysis on the documents is that they were obviously instructed from the 10th of August, because that was the point at which Jones Day thanked them for retaining them and explained that they'd already received instructions to act. So when the court was told on the last occasion that Jones Day had only been retained by the individuals on the 5th of September, we say that there's more to it than that. And in fact, it's pretty clear that the Jones Day had been retained for about a month. So that's my first point. Now there's a second point which is even more important, but I need to build it on the framework of that first point, which is who is the party actually giving instructions in this matter for the 1st and 3rd defendants? And that is made clear in the engagement letter. And if we go back to the engagement letter, please, and it's page 5147.
Yeah.
I'd like to take it slightly out of sequence just because it's easier to understand. But if you start with the staffing section under paragraph 3, and it says, as explained in the joint representation section above, and we'll look at that in a moment, you agree that
sorry.
So sorry, my lord.
Which page are we on now?
This is page 5147.
Yeah.
Which is the 3rd page of the 10th
Oh,
of August.
I'm sorry, yes, I'm with you. Yes, no,
So,
sorry, yes.
It says, as explained in the joint representation section above, you agree that Safra-Sarason's views and directions to us shall govern on all matters relating to this joint representation, including whether and when a settlement of the litigation is appropriate, and that we will take our instruction from Safra-Sarason on all such decisions. So that's instructions to Safra-Sarason on all such decisions, and those such decisions are on all matters relating to this joint representation. So it is clear from this engagement letter that is D4 who is giving the instructions for the 1st to 3rd, and actually, if we go then back to the joint representation section, which starts at page 5, the previous page on 5146, and it sets out some preamble about conflicts of interest. The most interesting aspect is at the bottom of 5146 in the paragraph that starts in a joint representation, and if your lordship could read that to the end of the paragraph.
Yeah.
So it's if there's a tiebreaker, it's Safra-Sarason who makes the decision rather than the individual defendants. And then the final aspect of this point is if we go to 5149, under the heading compensation and disbursements. It's Safra-Sarason who's paying the fees.
Yeah.
And so we say that they are the party calling the shots on this application. They're paying for it, and they make the decisions in terms of giving instructions. And even if there's a conflict between the individuals, it's Safra-Sarason's decision that goes. And we've asked for the engagement letter for the 5th defendant because we think that was probably the same engagement letter on the same date, and you can see that from 5146.
Could I just interject that it's not, because we wouldn't have entered an appearance on behalf of the 5th defendant without an engagement letter on file.
Okay, well that's the first time they've said that. I won't, in which case I won't pursue this much further, but I will say this on 5146, 2nd paragraph. Your lordship could read the 2nd paragraph.
Yeah.
What it seems to say is that Jones Day has concluded it can jointly represent D5 and D1 to 3 in this engagement on the terms and conditions set forth in this letter. And therefore, we think it's likely that the same terms and conditions apply to D5's representation, i.e., again, it's Safra-Sarason calling the shots. And that leads me to my 4th point, and really putting this all together. Your lordship will know from previous instances in this litigation that it has been D4. Sorry, I'll start again. Your lordship knows from previous occasions on this litigation that the defendants have been working together as a block. And I'll give you a couple of examples. One is the stay application that was made before your lordship. Now, that was nominally made in the name of D5, but interestingly, it sought a stay of the proceedings as against all defendants. And then similarly, before the last hearing, your lordship will recall that D4 made an adjournment application. But again, the benefit of the adjournment and the impact on it was for all defendants. And so we say that looking at the realities of how the defendants are behaving together, they are acting as a block, and that what we see today in today's application is again a decision by the fourth defendant as part of its overall strategy in this litigation, not an independent application by the first to third defendants. Now, your lordship will have your own view as to the extent to which that matters. And when one looks at those abuse of process authorities, it makes an enormous difference whether a party is essentially a privy of another party or whether they are an independent third party. But we would say that the decision not to run these points at the hearing on the 7th of September was a deliberate one by the defendants, that they had ample time in light of Jones Day's retention back on the 10th of August to pull together the material, and that they consciously decided to take the staggered approach. And that, we say, was designed to cause delay and disrupt the progress of this litigation. And your lordship will also recall from the stay application and also the adjournment application that on both of those occasions they wanted the proceedings delayed till December before anything happened, and your lordship refused both of those. But what they have engineered through these staggered applications is exactly the same result. That we're really looking at the earliest at getting this case moving and the pleadings rolling by sometime in the autumn, and we say that that is a strategic move on their part and not a proper way to conduct litigation. Now I won't go into further detail about relitigating issues, save just to remind your lordship that on the last occasion you did make it very clear to Miss Martin that the purpose of today was to take any new points. And I think it is worth just looking at the transcripts on that. That was at page 5518. During the course of the hearing, Miss Martin she also mentioned the fact that the D13 were working on evidence, and she actually talked about evidence being submitted, I think, the same day. But in the end, the application wasn't made that day. It was made after your lordship handed down the written reasons. But she explained that D13 were going to issue an application, and then your lordship asked, yes, sorry, the application is going to be for what? She said to contest the jurisdiction of the court, and you asked, so it would be for both extension of time and jurisdiction generally. She said that is correct. And then you said, OK, on the basis that there is some difference between those defendants and the fourth and fifth. And she said correct. And our understanding at that time was that they weren't going to relitigate points that are already decided. This was a chance simply to raise some fresh points that hadn't been canvassed before. And your lordship fairly said, yes, that is going to be quite ambitious, I'm bound to say, but you must take whatever course you think appropriate. And of course, that's not what they have then done. They have sought to relitigate the points your lordship has already decided. And we wrote to them before skeletons were due on this hearing, raising this point about relitigation and asking them to explain themselves. And they said, you'll see our position in the skeleton argument. But they made no promises in terms of not relitigating, and then one sees what's happened, which is a full relitigation. Now, as I said, your lordship will have a view as to whether this is an abusive process or not. We think actually this could fairly be categorised as either a Henderson and Henderson type abuse or a collateral attack type abuse. But as I said, your lordship will have a view, and I'm not going to press that. But I think I'm keen that your lordship understands what is happening in this litigation and the challenges that the liquidator is finding in simply just progressing the case. Now, perhaps
I understand all of that, and in the context of a situation where all these defendants were represented together by Clifford Chance and so on at the time of the letter before action. I mean, the conclusion I reached last time that the defendants had access to each other, absolutely clear. But that none of that seems to me to amount to an abuse at the end of the day. And Miss Martin, in a sense, has to put the points all over again, at least in form, if she wishes to seek some permission to appeal from the decision that I'm likely to make. So, you know, I'm just anxious, as I said to her at the beginning, I don't want to waste time over this because it's only the new stuff that's going to make any difference to my current thinking. But they have to put the points if they want to take this matter further, don't they?
Well, I think like the way we expected them to raise them actually was to say that we're not going to re-argue these at first instance. They are technically points pursued, but we will reserve them for an appeal, and that would have cut 90% of their skeleton argument out, and as a result, cut 90% of our skeleton argument out. So that we say that would have been the proper way to do it, and this hearing could have been much simpler and shorter. But anyway, I hear what your lordship says about that. Can I then turn to the extension of time application?
I mean, I've got the point about the powers of attorney and the fact that the lawyers could have picked up the documents if they wished to, and the backdated power of attorney point in relation to one defendant.
Yes, yeah, it was post-dated. That's right.
Is that the beginning and end of it?
It is, my lord, but the post dating is an important point, because we say that it was not an honest thing to do. It was designed to set up the argument that is run in Mr. Devenish's evidence, and I just want to take you to that because that evidence is not accurate. And that's Devenish 6 at page 4861.
Again, the paragraph.
Paragraph 41.
Yeah.
If the lordship could read that, and then I'll pick out a couple of points.
Yeah.
So it's towards the beginning where he says the individual defendants only executed the necessary powers of attorney after the deadline set by the claimants. Now, the deadline for collecting the claim form was the 1st of August. As Miss Martin says, that was actually a public holiday in Switzerland. But we know that the third defendant's power of attorney, although dated the 1st of August, must have been executed by the 31st of July at the latest. And it was post-dated. And we say that was dishonest and designed to set up this argument, and we say that that was one essentially contrivance on the part of the defendants to delay service, and there were also two others. One was, first of all, the decision of the defendants to send that power of attorney back in hard copy from the US to Switzerland, when it could have simply been signed and scanned and sent back, or it could have been executed by DocuSign, or on the defendant's own evidence. At most, it could have been executed electronically using something called a qualified electronic signature. And we've put in evidence. Lordship doesn't need to turn it up, but it's in our witness statement, Mr. Levine's witness statement, at bundle V, page 6564. And he says there that it would take 15 to 20 minutes to do one of these qualified electronic signatures. But he also says there that that's unnecessarily elaborate. You could simply just scan and sign the thing or execute it by DocuSign. So we say, again, the sending of the document in hard copy was another contrivance to delay service. And then the third way in which this was all contrived is that LNS, who I see are on this call, who are the defendant's Swiss lawyers, throughout this period had an existing power of attorney which permitted them to deal with the Geneva court. And of course, they were dealing with the Geneva court on the conciliation proceedings, but it also authorised them to collect any documents from the Geneva court. Now, the defendants were very reluctant to produce this document, and we had to chase them for it. And we had, in the meantime, found a standard form power of attorney from the Geneva Bar Association, which, although in different terms, effectively went to the same effect, which is that under the Geneva Bar Association authority, when you're instructed on a case and you get a POA, it tends to be pretty broad and allows things like the collection of documents. Now, we've put that power of attorney from the LNS had, we only got shortly before skeleton arguments were filed. So it was after all the parties had filed their evidence. We have filed a short witness statement in Mr. Levine's statement on it, which has a translation of that power of attorney as well. But the defendants wouldn't allow that to go into the bundle. So it's had to go into a disputed bundle, but your lordship does have the disputed bundle. Now, we say there can't be any proper objection to us putting in evidence on this in circumstances where it came in so late. But your lordship does need, we say, need to look at the terms of it just to see that it is sufficiently broad. So the actual power of attorney appears at 6573 of your bundle.
Yeah.
It's a one-pager. There's one for each of the individual defendants. There's a cast of thousands who are listed at the front of people who are all authorised at LNS to act on behalf of the defendants, and that includes Mr. Muller, who, as you know, has given some witness statements in this matter. I won't take you through the French. I will take you to the translation. Your lordship's French might be better than mine, but we'll go to the translation, which is at 6579.
Yeah.
And if you look at the end of the power of attorneys, it's a block of one paragraph, but
Yeah.
it's pretty broad. And amongst other things, it says, in short, to conclude, in the capacity of general agent, all legal acts and to appoint representatives for this purpose. So it's a very broad power of attorney. And if you go back to Mr. Levine's witness statement, which is at 6564.
Yeah.
And if your lordship could kindly read paragraph 9, please.
Yes.
So he makes it clear, and we say that it's obvious from a plain reading of the power of attorney that LNS had authority throughout to collect these documents. They had over a week to do it, but they weren't instructed to. And instead, what the individual defendants did is give power of attorney to the second defendant, and then he seems to have gone in person to collect the documents after the 1st of August. And we say that was just a contrivance. And just if you look at paragraph 10 of Mr. Levine's statement, and this is also in the evidence, LNS's offices are very close to the Geneva court, 24 minutes walking, 30 minutes by public transport, 6 minutes by car, or 9 minutes by bicycle. So there just can't be any legitimate excuse that none of those lawyers who were authorised couldn't in the space of over a week go to the court to collect court documents. Now, that was the way that your lordship put the point more generally last time, was that the you said that the defence had been deliberately uncooperative in declining to accept service by any other means than through diplomatic and judicial channels. We say that today you should make a further finding that they were deliberately uncooperative in relation to the collection of those documents from the Swiss court. And the reason I ask you to make that finding is we say that that finding is then determinative on this extension of time point, because we say the cause, the critical reason why the claim form wasn't served in time was because of these machinations on the part of the defendants, which were not proper. And if they had behaved properly, the documents would have been served in time. And that, we say, answers all the questions and simplifies the extension of time question. My Lord, subject to any further questions on that, I'd like to move on to deal with forum non-convenience next, please.
Yes, right.
So on forum, in summary, nothing has changed since your lordship's last assessment, save that in relation to Mr. Carton, as you have noted, he has an exclusive jurisdiction clause, which increases the threshold that he needs to hit to persuade the court to decline jurisdiction. The factors are as they were in your lordship's last judgment, but I want to identify 3 points that my learned friend raises that they say your lordship hasn't got right. Now, oddly, 2 of them are points which are raised before the Court of Appeal as points where they say your lordship went wrong and didn't take into account material considerations, but those points are not pursued today before your lordship. And we think that isn't appropriate or fair. So I want to draw those points to your lordship's attention so that your lordship can at least be aware of what's being said by the defendants in some context. My learned friend will then have to clarify whether or not those points are being pursued today. But they can't have it every way to tell the Court of Appeal that you failed to take into account relevant points and then not run those points here. So the first one is an authority that they criticise your lordship for not taking into account. And that's if your lordship finds their appeal skeleton, it is at 5560 of the bundle.
Yes.
And if your lordship has a look at paragraph 28, these are the sort of 3 factors that they say weren't given sufficient weight last time. If your lordship could just look at those 28.1 to 28.3.
Yeah.
We're going to look in a bit more detail at 28.1 and 28.3. So just looking at 28.1, which is sufficient weight to the Swiss proceedings. If your lordship goes to the next page, please, and it's paragraph 29.4. If your lordship could kindly read that.
Yeah. Yeah.
So now they say that your lordship didn't properly take into account authorities such as Galaxy. Now, Galaxy wasn't cited before your lordship on the last occasion, I don't believe that it is cited in their skeleton argument for this hearing either. But if my learned friend wishes to pursue this point, then you ought to be taken to Galaxy, because it seems to me you can't be criticised for not taking into account a case that no one's shown you. So I will let her do that if she wants to pursue this point. The other
point just doesn't go anywhere, because the everybody agrees that risk of inconsistent judgments is not a good idea, but that's not the determinative point at the end of the day. I mean, I think we discussed last time a case that I was in, DuPont and Agnew, where the court said, well, it's all very regrettable because each court has decided it has jurisdiction and won't stop the other court. And there'll be an ugly rush to judgment, to use the expression of the Aberdeen-Dava. But there are some situations where, regrettably, that's going to be the case because each court considers it has jurisdiction and ought to exercise it.
Yes, certainly, that's our view. Is that it would. Did
we discuss this last time? I can't remember.
We did, my lord. You weren't taken to that authority, and it seems to be that the defendant's position is that you didn't properly take it into account. If my learned friend wants to pursue that, she needs to share it to you. So that's the first point. And then the second point is this is the other factor which it said you didn't give sufficient consideration to. This is at page 5564 of their skeleton, paragraph 34. And it said that the judge gave insufficient consideration to the applicable law governing the conduct of the parties. That seems to be all parties. And then it says particularly those made against D4 and the other Swiss resident defendants, which I think is a reference to D1 and D2. Now, again, that point doesn't seem to be pursued here. They go on to say that there are Swiss law issues such as attribution and vicarious liability. Our position is that looking at it from an overview position, these are primarily DIFC law claims. We don't accept, and it is not said at the moment, that there is any material difference between Swiss law and DIFC law on things like attribution or vicarious liability. But even if that was an issue that the court had to grapple with at the trial of this action, that doesn't shift the overall assessment, which is in the main, in very substantial part, this is a DIFC law case. So we say that, although that point isn't pursued apparently now, it's a bad point. And in any event, would also say that your lordship is on top of it from the last hearing. So those are two of the additional points that I wanted to flag. The third is just a point that my learned friend mentioned in submissions about the residence of Mr. Carton. In your lordship's last decision, you referenced him residing in the DIFC. They dispute that. They say he was resident in Dubai, not in the DIFC. And you can see that they accept he was resident in Dubai from Mr. Devonish's 6th statement at paragraph 70.2. I won't turn it up, but I'll give you the reference. Actually, sorry, hold on. So I'm so sorry, my lord. Got a bad reference. Let me just get my reference. That's bundle O, tab 8. And it's 4867. You don't need to turn it up, but anyway, they accept there that his residence was in Dubai, and we just say it doesn't matter whether it's in the DIFC or Dubai. It's not Geneva, and it doesn't shift the gravity of this case from Dubai to Geneva. So, my lord, that's all I had to say on forum non-conveniens. Can I say a few words about lis alibi pendens?
Why?
Well, just again, there's a point they pursue in their appeal skeleton that they don't take before you, but in their appeal skeleton they say that you seem to recognise in your last decision that there was a principle of DIFC law, which recognise the concept of the doctrine, what they call the doctrine of lis alibi pendens. And we say it's really unsatisfactory for them to tell the Court of Appeal that that is the impact of your decision last time, but then not to run the same point before your lordship. If their position is that your lordship's previous judgment recognised that doctrine, they need to tell your lordship that. What they can't do is keep quiet on that before your lordship, and then go to the Court of Appeal and say that your judgment had a different consequence. And it's really, we say it's really unsatisfactory. So I don't need to dwell on that. They know it's in their appeal skeleton argument. If they want to run that point before the Court of Appeal, they ought to fairly put it to your lordship. But we also say the way they put the point to the Court of Appeal just mischaracterises your previous judgment, because it's quite obvious from your previous judgment that your lordship did not find that there was a mandatory stay regime under DIFC law in any circumstances involving a lis alibi pendens point. And I just say on that more generally that we find the defendant's use of the term lis alibi pendens quite unhelpful, because of course the Latin is pending other action or other pending suit, but they use it as a proxy for the Brussels regime, which is a mandatory stay. And lots of different jurisdictions use the term lis alibi pendens. They not often use it in the sense of the Latin rather than in the Brussels Convention sense, but sometimes it is used in the Brussels Convention sense. So one has to be quite cautious. Simply because an authority mentions lis pendens doesn't mean it's necessarily talking about the automatic stay, but that's how they use it. So then when they look at some of the, like the Horizon case and there's a reference to lis pendens, they say, aha, that's a recognition by the DIFC court that the mandatory stay regime applies. And of course, it's not.
Well, I mean, I couldn't have expressed the point clearer than in paragraph 17 of my reasons, could I?
No. Well, we think
never been part of the law of the DIFC that a case should be stayed on the basis of lis alibi pendens alone. Nothing to the point whether proceedings were first begun in another forum or not. Questions always which is the most appropriate forum. I mean, I couldn't have been clearer as to what I thought, whether it be right or wrong.
Yes, well, we agree with that. But if my learned friend says that your judgment has a different effect, and the way they put it to the Court of Appeal is that your lordship had essentially misapplied the doctrine, but recognised that the lis alibi pendens doctrine did apply, then my learned friend should take that point before your lordship. So, my lord, those are my points on the jurisdiction points and the extension of time points. There were some small directions points that I wanted to ask you about at the end. That's to do with the timing of defences, and also there's a very small point about the production of documents, which hopefully it won't be controversial. But it's up to your lordship the course that you want to take. But I'd propose to pause there.
Yes, we'll deal with any question directions at the end. Miss Martin, do you want to reply on any of these points? I don't think I need to hear you reply on points that you want to take in the Court of Appeal as to where I've got it wrong. I shall just assume that you think that I've got it wrong, and that you would be making these points here if you thought they were going to stand you in good stead, so to speak, but that I'd reject them.
Thank you, Your Honor. I would like to address the Henderson point, notwithstanding the court's inclination that it's not a good point, because I do feel like the integrity of my law firm is being attacked to a certain extent, and I do feel an obligation to protect it.
Well, you can put on the record what you want to put on the record, but I'm not very interested in the point.
Thank you, Your Honor. As to most of Mr. Shivji's points, nothing should be inferred from the standard language of our standard engagement letter. All that should be inferred is that we sent those letters for the individual's consideration on the 10th of August. That is the only point that can be taken from the dating of those letters and the wording of the letters. As to the conflicts language, now, I would ask the court and frankly, Mr. Shivji, to recognize that we are one general partnership worldwide. We have to conform to the highest watermark of ethical standards wherever we are, including on conflicts. The United States position on conflicts is much stricter than the SRA regime in the UK. And I also understand that barristers don't even really conform to the same standards, because I, curiously to me, had one case when I was in-house where I had barristers from the same chambers on both sides of the case. Blew my mind.
That is absolutely common.
Yeah,
No problem about that at all. But all independent. They all were independent.
And that's wonderful, but what that means to me is that he wouldn't be familiar with the type of conflicts language that's in our standard form engagement letter, which really is just there to allow the individual defendants to go find their own lawyer if they're unhappy with our representation, should they choose to retain us. That is all any of that language means. There's nothing to be inferred about our conduct or the conduct of the individuals from any of that. As to this insinuation that we were uncooperative in narrowing the issues, we actually did our best. We didn't repeat our skeleton arguments from last time, which the claimants did. And what Mr. Shivji leaves out in the correspondence between the parties is that you will see our skeleton on Friday. And if you have ideas about how to narrow the issues before the court, we would be absolutely happy to hear them. But it's not a matter of lack of cooperation on our part. And I wish that he would give the full statements of context when he's putting statements out there that we are behaving poorly. Mr. Carton in particular, I mean, people make mistakes when it comes to dating documents. Again, I don't know that there's anything that can be inferred from that. We certainly didn't ask our clients to date powers of attorney as a contrivance so that they could claim a particular date on which the documents were able to be picked up. And as for this, well, I'll get to the skirmish over the new evidence put forward by claimants in talking about extension of time. But I believe those are all my points on Henderson. Now, Mr. Shivji did note that of the cases, I don't think they put in any cases on Henderson abuse. I don't think they even put in Henderson itself. And from what I read about it, it should have been put in as a separate application if they were going to make the point. So we would submit that this entire discussion is a complete waste of time premised on an inappropriate submission on Henderson that should have been made through application. The cases that we read also stated that Henderson is a doctrine intended to protect defendants from having to face the same action twice. We didn't actually find any cases relevant to protecting claimants from having to litigate similar issues as to different defendants when it was those very claimants who wouldn't agree to a stay such that this is how the hearing ended up getting structured. We would have preferred to do all this at once. Everybody would have, but that's not how the hearing was scheduled. We accepted it, and we would agree with the court that all defendants should have be afforded the right to put forward their jurisdictional defenses. On the extension of time, the reason we had this debate over the new evidence proffered by the claimants on what it took to execute a power of attorney versus what it didn't is because they told us that we shouldn't have put in our evidence. And so they said, well, we won't object if you let us put in new evidence. So we're coming to a point of a sir reply, which our Swiss advice said was inaccurate, that frankly impeached their own prior evidence. The DocuSign was available, which our Swiss lawyers say is not available, on what are to us an absolute sideshow of an issue. Mr. Shivji has not pointed to a single case supporting the notion that claimants can be shown to have good reasons for their delay because of a couple of days delay by defendants in picking up some documents. No authority for that whatsoever. And so to the extent we're talking about defendants' conduct at all, it really is irrelevant to the legal standard here. As for whether or not the Geneva court would have accepted electronic signatures, what we would say is that the Geneva court actually collected and kept the originals of the powers of attorney. So it could have been the case that if they had shown up with electronic signatures, the Geneva court would have turned them away. We don't know because they did turn up with originals, but the Geneva court kept them, suggesting to us that if there's any inference to be drawn, is that the Geneva court required original signatures in that circumstance. On the Liz Pennon's point, we were clear that the court did not consider it to be a legal doctrine available to it in the circumstances. I don't think that we've misrepresented that point to the Court of Appeals. I think what we read in the order with reasons is that the court considered Liz Pennon's and forum non-convenience together. It was a little difficult to disentangle them, the analysis on them from our perspective, but there is a statement in there that where the court said that the Liz Pennons of the prior proceedings could be given weight if the cases are well progressed, or that is a point that the court could consider. Again, we don't find any basis in law for the progression of the proceedings or not, but that I certainly hope we didn't misrepresent anything to the Court of Appeals. We're not intending to bring things to their attention here that we have not fairly argued before the court at first instance. As to the applicability of other law, again, in our skeleton, we attempted to narrow the issues. We incorporated other arguments by reference, but just in case it is helpful to the court for me to list just some of the Swiss laws that we believe do apply to the actions of the parties here. The entire regulatory framework for this bank and its subsidiaries is under Swiss law and approved by FINMA, the regulator there. The Swiss law governs the shareholder activities. It governs the employment contracts of the first and second defendants, and it governs the general activities of the Swiss bank as to the clients of the first claimant. Now, of course, it's not disputed that Mr. Carton lived in onshore Dubai, but we would submit that there is a big difference between onshore Dubai and the DIFC courts. I don't see anything in the DIFC jurisdiction saying that activities onshore should be weighted in favor of DIFC jurisdiction. And in fact, I don't think we would have the existence of the Joint Judicial Committee and these other procedures that have become necessary to sort out jurisdiction as between onshore Dubai and the DIFC if you could really just sort of blur them all together and consider them to be the same thing. So Mr. Carton's residence in Dubai onshore 10 years ago really, we think, should not be weighted by the court. I'll conclude my points on that matter there.
Thank you very much. What I propose to do is to give a ruling now, and then we'll deal with any directions that may be necessary. The first to third defendants, who I shall describe as the individual defendants, challenged the jurisdiction of this court on the basis that first proceedings served on them in Switzerland were out of time and no extension should be granted in respect of service effected there. Secondly, on the basis that there is a lis pendens in Geneva in relation to the same matters as are in issue in the DIFC, and proceedings began there before proceedings were commenced in the DIFC. Thirdly, on the basis that Geneva is a more appropriate forum for the hearing of the dispute than the DIFC. The applications by the individual defendants represent essentially a rerun of the submissions made by the fourth defendant at a previous hearing. The fourth defendant, being the entity by which each individual defendant says he was employed in Switzerland, where he carried out most of his business activities, even when acting as a director or employee of the first claimant or the fifth defendant, both of which are DIFC companies. There is additional factual evidence before the court, which was not before it at the time of the applications of the fourth and fifth defendant, essentially to the effect that many board meetings were attended by the individual defendants on the telephone in Switzerland, with the result that board meetings, although not happening in Switzerland, are deemed to have taken place there under the Articles of Association of the companies. It is also said that particular communications and activities took place to and from or in Switzerland. It appears to me that this new evidence does not change the substance of my reasoning in relation to the applications made last time, nor therefore impacts upon my reasoning for the decision I have to make today. The reasons given for my decision on the applications of the fourth and fifth defendants still hold good, and I shall refer to them hereafter simply as, open quote, the reasons, close quote. The question as to where various acts took place is a matter of some dispute, some of which is perhaps clear enough, but others of which cannot be finally resolved here. But the impact of such acts being effected in Switzerland is said to be that the Geneva Court does have jurisdiction in relation to both the tort claims and the claims for breach of duty as directors and employees. Whether or not those activities are sufficient to create jurisdiction in the Geneva Court, that is not enough to make Geneva the more appropriate forum. Reference should be made to the reasons which specifically took into account the position of the individual defendants as referred to in paragraph 17 in the context of deciding which was the more appropriate forum for the claim against the fourth and fifth defendants. I first deal with the question of extension of time. The claimants apply for an extension of time, which is resisted by the individual defendants. The history of the matter appears to a significant extent from the terms of paragraphs 4 to 14 of the reasons given by me before. However, additional points now emerge from the evidence which reinforce the conclusion that the defendants were deliberately seeking to delay matters in order to require the claimants to seek an extension of time in the hope that this would in some way delay or block the proceedings altogether. The 25th of May 2023, the lawyers for the claimants wrote to Clifford Chance, which was then acting for all the defendants, enclosing a copy of the claim form and the consolidated points of claim, and inviting the first to third defendants to make an appointment for personal service. On the 26th of May, Clifford Chance confirmed it had no instructions on behalf of the defendants. On the 9th of June, the claimant's lawyers again wrote to each of the first and to third defendants, directly in this case, enclosing both the claim form and the consolidated points of claim, and told them that the claimants had initiated service by diplomatic channels and invited them to make an appointment for personal service. The Swiss lawyers, acting for all the defendants, Lenz and Stehlin, replied on the 23rd of June, stating that the individual defendants would not agree to be served otherwise than at their place of domicile in Switzerland. On or before the 20th of July 2023, the claim form was received by the Geneva court. On that date, it sent a letter to the fourth defendant ordering it to collect the claim form before the 11th of August 2023, failing which the document would be served upon it by the police. That letter appears to have been received, or is stamped as being received, on the 24th of July 2023, and from inquiries made with the Geneva court, it emerges that similar summonses were sent to the individual defendants. On the 26th of July, the lawyers for the claimant wrote to Lenz and Stehlin requesting that the individual defendants collect the claim form from the Geneva court by the 1st of August, identifying that as the date by which the claim form had to be served, failing which it would be necessary to apply to this court for an extension of time. On the 28th of July, Lenz and Stehlin replied, saying their clients would not comply with the request, since it was summer holiday season, and as such, the availability of their clients to comply with the deadline on what was effectively one business day's notice was doubtful. They said they were unaware of the 1st of August 2023 being a deadline, save to the extent that that was effectively self-imposed. It is now clear from documents which have emerged that in fact Lenz and Stehlin had standing authority from the individual defendants to collect such documents. They were authorized to do so and could have done so if they so wished, their offices being close to the court. There was no need for any powers of attorney to be issued, which was in fact the course then taken, by which the individual defendants authorized the second defendant to collect the documents on their behalf. From the point of notification by the Geneva court, it would seem that Lenz and Stehlin had some 6 days to collect should they have chosen to do so. It is perfectly plain that had the defendants wished to be cooperative, they could have done so, and although not obliged to go to the court to collect those documents before the 11th of August, the date set by the Geneva court, it is clear that the reason for not doing so would be to create as much difficulty as possible in the way of the progress of these claims. In the case of the third defendant, not only did he issue an unnecessary power of attorney in favour of the second defendant, since Lentz and Staling were already authorised to act, but he post-dated, or backdated, I should say. Let me put that again to make it clear. Although signed on the 31st of July, he dated it the 1st of August 2023. The reason for that is not at all obvious, unless it was specifically to give the impression that the date of 1st of August had already passed by the time that he put his signature to such a document in such a way as to indicate that collection prior to the 1st of August was impossible. It is in that connection that reference has been made to paragraph 34 of the 6th witness statement of Mr. Devenish, which is therefore not accurate. This context it is also pointed out, and this is a matter of dispute between the Swiss lawyers, that there was the possibility of powers of attorney being signed electronically or signed and scanned, and such documents being presented to the Geneva court in any event without the need for the originals to be put forward. I need not make any decision about which of the Swiss lawyers' views are accurate on that, but it does appear to me that the points taken by the defendants are all part and parcel of the same objective to which I have already referred. Whatever delay there may have been between February and the end of May, as noted in the reasons previously given, it is clear that the defendants all sought to delay service in the hope of gaining some advantage thereby. Although, as I stated in paragraph 12 of those reasons, no defendant is bound to accept service by any means other than those provided by any applicable statutory or treaty regime, it does not lie in the mouth of an uncooperative defendant who has been given every opportunity to accept service to complain when an extension is sought as a result of the approach taken by him. The claimant's attempts to serve proceedings by one means or another, and to avoid the need for service through diplomatic or judicial channels, and then to encourage acceptance of service by such means within the time limit set by the court of 6 months, represented a reasonable course of conduct, and to refuse an extension of 8 days would be wholly unjust in such circumstances. As I found in the reasons given before, the claimant's approach was entirely reasonable, and whilst no specific criteria are set out in relation to extensions of time for service of proceedings where the application is made before the expiry date, a proper exercise of judicial discretion inevitably results in an extension of time for such a limited period in the circumstances which I have described. As a result, I extend time, and the individual defendants have therefore all now been validly served with the DIFC proceedings. I turn then to the question of forum conveniens, embracing within it the arguments that have been raised about lis alibi pendens. In my previous reasons, I set out the relevant principles of law. Lis alibi does not constitute a separate ground for objecting to the court's jurisdiction. It is a factor only in the context of forum conveniens and consideration of which is the more appropriate forum for the hearing of any claims. Whilst there may be room for argument about where various acts took place, and I now have additional evidence about that from the defendants, and therefore whether the Geneva court can itself consider that it has jurisdiction over the claims in tort and for breach of director's duty, the following is now clear as matters currently stand. 1. The claims will proceed in the DIFC against the 4th and 5th defendants in accordance with my previous decision. They will proceed on the basis of breach of duty as directors in misappropriating the first claimant's business and diverting it to the 5th defendants, regardless of any banking relationships, credit facilities and products or assets of customers in Switzerland or other locations. The claims will also proceed against those 2 defendants, the 5th defendant being in any event a DIFC company, both in tort and under the insolvency regime, to which I shall refer again in a moment. Secondly, the 3rd defendant is bound by an exclusive jurisdiction clause in his contract of employment with the claimant, with the first claimant, which means that the court would need very strong reason to say that he should not be kept to his contract. The claims against him for breach of his duties as an employee in tort and under the insolvency regime will all proceed against him also, where I find there is no strong reason why they should not. It is clear, thirdly, it is clear that for any claim made under the insolvency regime in the DIFC court is clearly the more appropriate forum. See paragraph 24 of my previous reasons. It is DIFC insolvency law which is in issue in relation to a DIFC registered company with a DIFC officer of the court as liquidator. Fourthly, a claim for breach of duty as a director of a DIFC company governed by the law of the DIFC is much better heard in the DIFC than in Geneva, even if the Geneva court considers it has jurisdiction also. The location of board meetings has limited bearing on the question of where the company is administered, and there are many other factors which indicate that the company was administered in the DIFC. A reference can be made to paragraph 22 of the reasons that I gave previously. The first claimant was incorporated in the DIFC, its head office and registered offices were located there. It was regulated by the DFSA, and most of its staff was based there. The shareholders' agreement, to which the 4th defendant was a party, required the management and control of the first claimant to be exercised in the Emirate of Dubai, in the UAE, and required shareholders to use all reasonable endeavours to ensure it was treated for all purposes including taxation as a UAE resident. Whilst, of course, onshore Dubai is not the same as DIFC, as is obvious, nonetheless, the connection with the DIFC is much closer than the connection with Switzerland. Criticism is made of the suggestion that the third defendant was resident in DIFC when the evidence now shows that he resided in Dubai, but he nonetheless worked from the DIFC. Moreover, insofar as board meetings took place and were deemed to take place in Geneva because representatives were in Geneva, that really can make very little difference to the questions that I have to decide. The fact that something is deemed to take place in a particular location is not conclusive as to the location of administration of the company, in fact. Fifthly, when one looks at the question of location of the tort claims, one has to consider the nature of the claims in question. They are for unlawful conspiracy. The Geneva Court is an available forum if the place of the act or event giving rise to the damage was in Geneva, or the place where the result occurred was in Geneva. Assuming that this point is sufficiently evidenced by the materials that have now been produced, what it goes to is to show that Geneva would be an available forum. It does not, however, make it the more appropriate forum. Sixthly, it is clear that if the claims already mentioned against defendants 3, 4, and 5 will go ahead in the DIFC, it is obviously in the interests of justice and in the interests of the parties that all related claims should be heard together in one jurisdiction, whether those claims be in tort for breach of duty as directors or employees, or under the insolvency regime of the DIFC. Seventhly, this is not a case about shareholder actions or a breach of the shareholders' agreement. It is an action brought by the first claimant company and the second claimant as its liquidator against the individual defendants, in addition to the fourth and fifth defendants, as the former directors and employees of the first claimant for breach of their duties in a number of different ways. The governing law of their employment by the fourth defendant is irrelevant. It is the governing law of their employment by the first claimant that matters, and the governing law of the claims as framed. The location of the fourth defendants and their location is not of any great significance either, save in relation to questions of availability of evidence and documents. The fact remains that the case as presented by the claimants centres on the movement of business from one DIFC company to another by the directors of the former in breach of their duties imposed by DIFC law, as alleged by the claimants. The scheme, according to the plaintiff's pleadings, was primarily enacted in the DIFC and related to a largely DIFC-based business operated by a DIFC-registered and DFSA-regulated company, and resulted in the transfer of that business to another DIFC-registered and DFSA-registered company, which continues to operate in the DIFC today. The key individual in proposing and executing the scheme is said to be the third defendant, who at all material times was the chief executive or senior executive officer of the first claimant. Wherever the individual defendants were at any particular time, the scheme, as alleged, at least appears to have been hatched in Dubai and the DIFC. On the evidence, it was proposed from Dubai through the relaunch plan email, which included an appraisal of the value of the business of the first claimant. It was then primarily enacted in the DIFC through the solicitation of the relationship managers and their solicitation of the on behalf of the fifth defendant. Even if meetings with clients took place in Dubai rather than the DIFC, this still points to the DIFC as being a more appropriate forum than Switzerland. It matters not in this context that the transfer of clients mainly involved their former relationship managers, now at the fifth defendants, contacting them and inviting them to terminate their relationship with the first defendant and to establish a new relationship with the fifth defendants in the DIFC, whilst also authorizing the fourth defendant to communicate with the fifth defendant in respect of the custody accounts. The place where the internal records are kept does assist in relation to where documents will have to be found for the purpose of these proceedings, but that does not change the fundamental question, which is where the center of gravity of this dispute is located. The center of gravity of this dispute, as I see it, is the DIFC. Witnesses may have to travel, though it is not said that any of the defendants will specifically participate in any trial and appear for the purposes of giving evidence. But in any event, it is not significant in an age of international travel or with internet platforms exactly where those individuals are located. It seems that the third defendant is essentially resident in the USA and would have to travel in any event to one jurisdiction or another. English language and English documents point to the DIFC as more appropriate in any event, as previously pointed out. The reality is also that although I do not consider there to be any question of abuse of the court, the individual defendants have brought applications which could have been brought earlier, together with those of the fourth and fifth defendants, on much the same grounds, but with some additional evidence of fact which could have been adduced at the earlier stage by the fourth and fifth defendants. These defendants are represented by the same lawyers as they have been from earlier days, albeit by different lawyers, and are cooperative one with the other. The evidence now shows that there was a letter of engagement sent to the individual defendants on the 10th of August 2023, which they returned signed on the 5th September. But the terms of that letter, albeit no doubt in standard form, certainly indicate that not only were the Swiss lawyers representing each of the defendants from that date onwards, but that the fourth defendant was giving instructions which were to prevail over any instructions which they might give. It is clear as a matter of inference that these defendants work together, and that the fourth defendant is pulling the strings as well as paying the bill of each of the individual defendants. Ultimately, the applications of the individual defendants must fail for much the same reasons as I gave before in relation to the applications of the fourth and fifth defendants. The centre of gravity of this dispute, as already mentioned, is in the DIFC, and in particular claims under the insolvency regime, and claims in tort, and indeed the claims as breach of duties as directors and employees, all being governed by DIFC law, must be better heard in the DIFC than anywhere else. The fact that the defendants sought to preempt such proceedings in the DIFC by launching proceedings for negative declarations in Switzerland does not really assist. What the defendants' argument comes down to is that this court should not exercise its jurisdiction simply because the defendants have launched such preemptive proceedings in Switzerland, even though this court is much better equipped and is much more suitable to try the issues that arise between the parties. Paragraph 34 of the reasons that I previously gave, I invited the individual defendants to consider their position when I was told that they were likely to launch applications challenging the jurisdiction. Invited them to consider the reason that I had given to evaluate the prospects of success in their doing so. They chose to bring this application regardless of that, which fails for much the same reasons as given. Circumstances where the court has dismissed the arguments made by the fourth defendant, the jurisdiction applications which are brought by the first to third defendants do not disclose any new grounds which would lead to a different result. This is a claim which is alleged to be based on fraudulent activities perpetrated in the DIFC and based on issues of DIFC law, with the removal of assets from a DIFC company in liquidation, with a view to avoiding payment of a judgment to which that company was subject. Though it cannot properly be said that the applications made by the individual defendants are an abuse of process, the defendants being different, and it being open to them to take such points as they wish. The lawyers representing them are the same. The defendants cooperate with one another as they have throughout, and considerable expense has been incurred when these defendants could have accepted that the reasons I have or had already given applied with equal force to their application, whilst preserving their right to seek any permission to appeal they might think appropriate from what would properly be regarded as an almost inevitable decision in the light of what I had previously said. If an application is now made for permission to appeal, I shall deal with it, but it is fairly obvious from what I have said that I am likely to refuse it. All right, that leaves the question of costs to be dealt with, directions to be given, and any application for permission to appeal.
Just to answer that question very quickly, we do seek permission to appeal.
Yes, well, as anticipated, I imagined you would, and as you no doubt anticipated, I refuse it on the basis that it has no realistic prospects of success. Yes, Mr. Shitji.
There was just one. Sorry, I think it's a bit of an echo. Maybe Miss Martin could just put herself on mute, please. Grateful. My lord, there's just one point in your judgment. When you were referring to the engagement to the 10th of August, you then referred to the representation by the Swiss lawyers. I think your lordship meant Jones Day, because you were talking there about the Jones Day letter. Is that correct?
That's absolutely correct. Thank you for pointing that out. I misspoke.
I'm grateful. We'll read
there'll
it.
There'll be a transcript, so a transcript of my judgment will be provided to me for approval, in which I can eliminate obvious grammatical and syntactical errors and infelicities of one kind or another, and then it can come to you as necessary. But thank you for pointing that out. I hope I shall pick it up when the time comes.
Thank you, my lord. No, well, it's that on that point. It's fine. We'll obviously read the judgment accordingly. My lord, just a few short points. I hope there are. I asked for directions on the deadline for defences. That just to make it clear, it's obvious, but that's without prejudice to any appeals that the individuals defendants might want to bring, or in fact the D4 and D5 are trying to pursue. Our position is that the court, we ought not to delay matters further. The court can now give directions for statements of case, and we will obviously accept that the filing of any statement of case won't be a submission to the jurisdiction to prejudice any appeal. So that's one point that I wanted to put before your lordship. The other is that there is a very short. Sorry, my lord.
Oh, go on, you go on. I'll come back to you in a minute.
There's a short point about the production of two documents which are mentioned in the evidence. The DIFC has the same rule as exists in England. In England, it's CPR 31.14, which is that a party may inspect a document mentioned in a witness statement there is an identical provision under RDC 28.5.
Yes.
There are this relates to D1 and D2's employment contracts. They are mentioned in the evidence. We asked if this is in Devon 6. There's no dispute about that they're mentioned. We've been given redacted copies, and the redactions seem quite extensive. The only explanation we've got for the redactions is that they relate to sensitive information such as salary. As I said, they're quite extensive, so it doesn't look from the redactions that they can be limited to salary information. They seem to go to other matters. The RDC is quite clear that essentially redaction is the exception rather than the norm. You either need the agreement of the other parties or permission of the court for a redaction. These are documents we want to see. It's obvious that the liquidator considers them material and wishes to see them. There isn't actually a relevance test under CPR 3114 or RDC 28.5. But the argument between us in any event is just about the redactions. And we say we should just get unredacted copies. We find it difficult to see how there's a legitimate concern about confidentiality because these documents are a decade old. But of course, your lordship has the power to put in place confidentiality provisions, confidential to clubs, etc., if there was genuinely confidential information. So even confidentiality can't be an answer to this. And I would like an order today from your lordship that they are ordered to produce those two documents under RDC 28.5.
May it be heard on this point?
Yes, in a second. Let me first deal with the question of defence and so on. I mean, there's a difficulty here, isn't there, Mr. Shivji, because the defendants may well choose not to put in an acknowledgement of service following whatever happens in the Court of Appeal. And in those circumstances, they wouldn't be bound to produce the defence. You know, they would simply let this matter go to trial and not appear. That appears to me to be an option which I can't foreclose. And in those circumstances, it doesn't seem to me to be right that they should be compelled to put in a defence.
So my lord, I think we're on the same page on that point. We're not looking to compel them to put a defence in, but what we want to do is put in place a timetable so that if they were proposing to defend these proceedings, we have that defence. I mean, our concern is really what I said earlier, that they asked your lordship back in June for a stay of this action to December. That is effectively where we're going to end up, even though your lordship thought as a matter of case management that was not appropriate. And for the fifth defendant's defence, that because of the relief from sanction application failing, their defence was actually due back in June. Now, we don't object to giving them some more time, but our view is we really want to get on with it. What we want to avoid is when the appeals are all exhausted, if we, as we hope, prevail, the defendants at that point say, oh, well, we need another month or 2 months to file our defence. I mean, that is just unacceptable, especially in circumstances where, in the meantime, they're progressing their conciliation proceedings. And as your lordship said back on the stay application, what we want to avoid are these proceedings. Sorry, Miss Martin's on. Thank you. What we want to avoid in these proceedings is an unseemly rush to judgment. But what we, the liquidators, are trying to do is just progress the proceedings in a sensible fashion so that there isn't enormous delay early in the DIFC proceedings. And of course, this is against the backdrop where previously the defendants have been trying to persuade your lordship that the Swiss courts are far more efficient and speedy than the DIFC courts. So it seems to us it's not in their mouth now to say that the court ought not to get on with it.
Yeah, I still have a problem, Mr. Shivji, because assuming as I do that these defendants, the individual defendants, will apply for permission to appeal to the Court of Appeal, however misguided I might think that is, they're plainly not going to be putting in an acknowledgement of service accepting the jurisdiction of the court until such time as that has been exhausted. And even when that appeal process is exhausted, and assuming for the moment that it fails, they're still not bound to put in acknowledgement of service or defence of any kind. So I'm unclear really what order it is I can possibly make that's going to assist.
But as we understand the RDC, my lord, that this is in our skeleton. So ordinarily on the dismissal of a jurisdiction application, the court, if your lordship turns up our skeleton, it's paragraph 61.
Yes.
So as we understand it, the RDC 12.8 requires the court, it says the court shall give directions as to the filing and defence of filing and service of defence in a claim under Part 7 or the filing of evidence in a claim under Part 8 in the event that a further acknowledgement of service is filed. So as we understand it, of course, they're not obliged to file another acknowledgement of service. They're not obliged to participate in these proceedings any further. We understand that. We also understand that we're not looking to prejudice them in any appeal. I'm certainly not trying to get your lordship to make an order that renders their appeal moot. But what I'm trying to do is come up with a timetable that ensures that this matter can progress speedily from here on. Now, in relation to D4 and D5, they have a pending application for permission to the Court of Appeal, which has not yet been determined. For the individual defendant, we can assume from today that they will also take the same course, and that will also take some time to be determined. As I said, I don't want to prejudice that. My preferred scenario would be for the court to set a date in the future for all of the defendants to file a defence. But if your lordship didn't want to do that today, then I would suggest at least that we set a date for them to file their defences anchored on the refusal of permission to appeal or the appeal itself. And I wouldn't. My proposal is that I wouldn't indulge them by giving them any extra time beyond those dates or any material time, because they've had a very long run up to do this.
I can understand that. The date, if they would be bound, would they, to decide whether or not to put in an acknowledgement of service within 14 days of any refusal of permission to appeal by the Court of Appeal or dismissal of an appeal. Is that right?
Can we check that point, my lord? I don't believe that is the case. I don't believe that the RDC deals with this. So sorry, let me just get 12.
I'm looking at 12.8.
Yes.
Which of course deals with the position at first instance.
Exactly. So they have 14 days from the dismissal of the application to put in an acknowledgement of service. If they don't do that, the fact that they've appealed to the Court of Appeal and then lost on permission or the appeal itself doesn't give them extra time. So the date for that event having occurred has already passed, and they would presumably have to then apply for relief from sanction.
Is there nothing in the appeal rules that deals with it?
We don't believe so. And I'm grateful to my junior, Mr. Sampson, who passes me a note to say that one must remember that an acknowledgement of service is not a prerequisite for a defence. So if you file an acknowledgement of service, you get more time to file your defence, but you don't have to file an acknowledgement of service in order to file a defence. And for our part, we're quite relaxed about the acknowledgement of service. But what we want to do is get to a position where if they are proposing to defend this action, that defence is filed promptly. And obviously, although we could technically, for example, against D5, apply for default judgment because their defence was due back in June, the liquidator's being sensible about this. We're not taking silly points like that. We just want to try and progress the statements of case as swiftly as possible.
Well, it seems to me that what I can do is order that a defence be filed within 21 days or something of today's date, if no application is made for permission to appeal, or in the event of an application being made for permission to appeal, the defence be served within 21 days of the determination of that application or determination of any appeal, whichever is the later.
Yes, well, that's an available order to your lordship. And my preference would have been to squeeze those timescales, because we very quickly end up with December or later, which is what we understood your lordship wanted to avoid.
Well, I understand that, but I have no control over how quickly any permission to appeal application will be dealt with, or any appeal should permission be given.
Yes, well, when I hear that, when I hear that, my lord, and I mean, I've made my submissions. I mean, our positions, we just want to progress it, and we're obviously trying to be sensible about this.
Ms. Martin.
Thank you, Your Honor. We would just ask also that, as a predicate matter, that the claimants be required to provide all the documents supporting the consolidated particulars of claim before any defendants are required to file any defenses, and that sufficient time be given to digest those documents. We have requested them on a number of occasions. The claimants have always refused, and at most referred us to a total of 7 documents that were provided to Clifford Chance with the letter before action. We think it would be prejudicial on any schedule to have to respond to the consolidated particulars of claim without access to those documents. But our proposal to claimants was actually dependent on the determination of the appeal, and so we are grateful that the court is inclined to accommodate us in that regard.
Yeah, well, I can't compel you to put in a defence whilst you're still taking jurisdiction points. But so far as the documents are concerned, which documents are you talking about?
Any of the documents cited in the consolidated particulars of claim. There are a number of supposed emails and communications and other documents that they say are matters of fact that we don't have access to.
Well, the rules of court provide that if a document is referred to in a pleading, it must be produced. So self-evidently, that's got to happen.
Could I know we're on scheduling right now. I do want to address the employment agreements at the court's preference.
Yes, no, I was about to come to that, but I'm going to make an order then that the claimants produce any document that's referred to in the consolidated particulars of claim within 7 days of today's date. I'm going to order that.
Sorry, my lord. Perhaps would you mind hearing me on that point, because I don't accept what my learned friend has said about that. We've obviously given them a substantial amount of material along the way. This dispute has been going on for more than a year, with lawyers instructed on both sides and detailed discussions. If they think they are missing any document mentioned in our statements of case, they can write to us under 28.5 and identify those documents. And in my submission, that is the proper first step. And the documents I am asking your lordship to order us to get today are ones that we have already requested in that way. But in my submission, it wouldn't be fair on us to now then have to try and do a trawl through our own pleading to work out what they haven't got, or what they think they want, or what they think is mentioned. The rules are quite clear that the burden is on them to identify the documents mentioned, and of course we have an obligation to give anything mentioned, and the liquidator fully recognises that. But I'd ask your lordship not to reverse the burden on that, especially where we are actually the only party who has progressed this proceedings in accordance with the rules, and they are at the moment are a party who's not engaged at all in the substance of this dispute.
I would submit that the burden goes the other way, Your Honor. The obligation is on them to produce every document on which they rely on the consolidated particulars of claim, and the court is entitled to draw an adverse inference against them if they fail to produce it. The burden should not be on us in terms of time or expenses or just labor to have to go through and identify what we think they produce versus what they haven't. They're the ones who are anchoring their reliance on these documents, and they should be made to produce them.
Point me to the relevant rule, please.
It's 28.5, my lord. And my letter is quite wrong to say that we have to produce every document relied on for the statement of case. That may be the position in other jurisdictions. It isn't even fully the position in England under the new disclosure regime, which is different to the RDC. But there is absolutely no rule in the RDC that requires a claimant to identify every document relied on and to provide it alongside the particular claim. The only regime is the 28.5, and there the burden is on the receiving party to identify the documents mentioned. And as your lordship knows, there's an authority on what mentioned means, and anything mentioned we obviously have to give, and if we're not willing to give, they'll have to make an application and there would be an argument over that. And all I'm asking is that standard regime is applied and there's not some reversal of the burden.
Ms. Martin, on the face of it, 28.5 appears to be the relevant rule. Is that right?
If the court can give me just 1 minute to send with the rules, please.
Mhm.
Your Honor, I would reference 28.5, which says that a party may inspect a document mentioned in a statement of case. That is a basic requirement, and so it says to me that the claimants need to produce all of them.
Right. Well, that is the relevant rule. Certainly a party doesn't have to produce every document on which it relies. The rules provide under 28.7 that if a party wishes to inspect documents referred to, I'm sorry, that's in an expert report. But the first position should be that you should identify the documents you want to inspect before you make any application for inspection, that the claimant should produce such documents for inspection where they are mentioned in the statement of case under the terms of 28.5. And if there's a dispute, then an application will have to be made for such documents. So what I'm going to order is that within 7 days, the defendants identify documents they wish to inspect, and within 7 days thereafter, the claimants produce such documents for inspection. And if there's a dispute about it, then an application will have to be made thereafter. So that's those documents. Now, great. What about the employment contracts, Ms. Martin?
Thank you, Your Honor. We've taken additional Swiss advice on them, and they have business secrets in them, which are subject to Swiss blocking statutes, meaning that the way for claimants to obtain them, if they deem it important, is through mutual legal assistance. We put them in on the sole basis to show that Swiss law governs the employment contract, because they were relevant in our view to the jurisdictional dispute for that point. that point is fully available to the claimants. They weren't deprived of anything in regard to jurisdiction, but if they want them on the substance, they will have to make an application for mutual legal assistance to obtain those documents, so as not to invoke potential criminal liability, frankly, for providing them if the Swiss defendants were to do so.
Well, is this based on banking secrecy laws in Switzerland?
I understand it is based on business secrets. I have a citation to a Swiss statute here if Mr. Shuji wishes to challenge it. Give me just one moment. I understand that it's not under the banking secrecy, just the Criminal Code and Data Protection Act.
Well, that can't be right, can it?
The blocking statutes they're quite severe.
Well, I understand, they're beginning to see the light about banking secrecy in Switzerland, but the process appears to be slow. But regardless of that, I mean, I can't decide this on the basis simply of say so on one side or the other.
May I just add the citations to the relevant articles? I'm sorry for interrupting. Articles 271 and 273.
Yeah, I know. I don't have it in front of me. If I'm going to decide a real argument about this, I shall have to have all the material made available, and the point will have to be properly argued. Sure. But the starting point must be that if you've relied on a document and produced it, you ought to produce all of that document, unless there are reasons in law why you can redact it. In the ordinary way, if there's confidentiality involved and sensitivity involved, that can be catered for by a confidentiality ring, where the document in its full form is only produced to lawyers or particular individuals on one side and doesn't go to the clients, and so on and so forth. If there are laws, Swiss laws of secrecy of one kind or another that mean you can't produce at all, then that will have to be justified. And all of that I can't decide here and now without all the material being made available and the point being argued in proper form. So what I'm going to suggest is that you, again within 7 days, write a letter in which you set out properly why it is you say that the redactions are incapable of being unredacted, and set out the authority for it. And if there's an issue, then there'll have to be an application to the court to determine the matter with evidence of Swiss law and so on and so forth. All right. I'm not going to just suggest that. I'm going to order it.
I'm grateful. My lord, would you be willing to order that they provide a witness statement verified by a statement of truth on that? Because I think we will pursue this, and if their position, I think it would help us if a lawyer on the Jones Day side had looked at this and exercised their own professional judgment. I think it would be troubling if the clients are putting giving information to Jones Day, and then Jones Day is setting that out in a letter without any independent verification.
There's going to be Swiss law relied on, and there's going to be a dispute about it, then I shall have evidence of Swiss law. And that'll have to come from qualified Swiss lawyers by way of witness statement, and I suppose worst comes to worst, even cross-examination, but I hope not. Ms. Martin, you hear the point. This has got to be properly investigated and Swiss law properly sorted out and explained. I'm not going to require you to produce a Swiss lawyer's witness statement at this stage, but your explanation must be full and be based on Swiss law advice. And, you've got that readily to hand because you've got Lenz and Staling on board already. They can they can set it out in an opinion or whatever.
Well noted, Your Honor.
I think that the quickest way of dealing with the dispute would be for you to, I'm afraid, spend the money on Swiss lawyers at once and get an opinion from them which can be put forward and which, if necessary, you can rely on in this court if the dispute should continue. Can you do that within 7 days?
I believe so. I'll come back to the court if we think 7 days is a problem.
Yeah, we'll say 7 days with liberty to apply if there's an issue. All right. So apart from costs, is there anything else that needs to be done, or will you be able to agree the order between you that I've made? It should be plain on the transcript.
That's very helpful, my lord. If like last time, we're content to take carriage of the order and do the first draft, and then we'll agree with Jones Day. And I'm grateful to Miss Martin and her team last time for being so efficient in getting that agreed. So thank you. My lord, just one point on the order that you made in relation to us and the directions you gave for 28.5. I think you said that Miss Martin should, within 7 days, identify the documents they want to inspect. That is, of course, the documents mentioned in our statement of case. So that's 28.5 documents.
Yes.
So that we don't get a longer list. That's fine. We'll put that into the order. So, my lord, those are all the points from us. The only outstanding question is costs, and we have submitted cost schedules. We've submitted costs on the one hand on the extension of time, and then separately on the other jurisdiction applications. I'd like your lordship to assess costs today. There is also the question of, sorry, my lord.
Where are the schedules, page numbers, please?
The schedules are 6735.
Your Honor, before we're made to respond to Mr. Shivji's submission on cost, could I have 5 minutes with my colleagues who've been working on this while we've been conducting the hearing matters?
Yes, if that's going to help, certainly.
Thank you.
Where are we now? Well, let's take 10 minutes out now so I can have a cup of coffee, and then we'll sort out costs after that. All right. So it's now. I make it quarter to the hour. So 5 to the hour, please. All right.
Thank you very much.
Mr. Shivji, are you there somewhere?
I am, my lord. Can you see me? I can see me, but can you?
I can't see you as it happens now. Oh, there you are.
No, I'm
yes.
sorry, my lord. Okay.
Yes. Miss Martin, were you attempting to foreshorten matters somewhat, or just taking instructions generally?
Just taking instructions generally. Thank you for affording me the time.
Okay, fine. All right. We were looking at page 6735 to 6737.
Yes, my lord. So there is. I asked the court to order our costs on the jurisdiction challenges, and then separately on the extension of time challenges. And we'll come. This schedule of costs only deals with the jurisdiction challenges. I'd ask your lordship kindly to summarily assess them today, please. On the last occasion, I asked your lordship. I made submissions on the basis of the costs order, but it seems to us today that there's no need to do that. If your lordship summarily assessing the cost, your lordship can take into account all of the factors that have led to these costs being incurred, including the fact that we have had to rerun sometimes slightly differently arguments that were foreshadowed last time. I mean, we say that these applications could have been presented far more narrowly and efficiently, and that would have very substantially reduced the amount of work that we had to do. Many of the points that they have taken are rehashing of previous points. and sometimes facing the opposite way. So, for example, on this alibi pendants and the mandatory stay point, last time their submission to your lordship was that it was part of English law, the mandatory stay point, in particular raised under English authority, i.e. under the common law. And this time they argue the opposite. They say it's not part of the English common law, but that your lordship should reject the English approach and instead prefer some international approach. And I heard what your lordship said about abusive process, but that sort of conduct on behalf of the defendants obviously increases our costs. So I would say if your lordship can take all of that into account in looking at the number.
Right, and where's the other bill?
The other bill is the next tab in the bundle. So that is at 6738 on extension of time. Now, this bill covers our costs since the last hearing, and your lordship may remember, or I can remind your lordship, the last hearing we showed your lordship a cost schedule for the extension of time application against all defendants, and I asked your lordship only to order half of them against D4 and D5 because I said the other half related to D1s to D3. So there is the hangover from that schedule, and that was the amount of the schedule was 77,182. So that's in addition to this schedule. And if Mr. Sampson could just pull out the figure that it was actually assessed at, that would be helpful as well, please. And I'll give you that figure in a moment, my lord.
I think I awarded you 20,000, didn't I?
No, I think no. That is. I'll get it up.
It was 60,000 dirhams that was awarded last time.
60. It was 60. I'm grateful, Miss Larson. Thank you. So yes,
sorry.
The figure was 77,182, and of that, your lordship assessed it at 60,000. Our recollection is that your lordship was applying about an 80% recovery rate. So following the logic of that, it would be 60,000 again, plus the additional cost incurred since.
Completely lost the plot here.
Okay.
First, are we talking dirhams or dollars or what?
We're talking. I'm sorry, my lord. I've taken it too swiftly. So let me start again. For the jurisdiction challenges, your lordship has one single schedule of costs, which appears at 6735. That is all of our costs on all aspects of the jurisdiction challenges for D1 to D3. For the extension of time position, the position is a little bit more complicated. There are our costs up to the 7th of September, which we have split 50-50 between these defendants and the corporate defendants. Now, on the last occasion, so 50% of that figure is 77,000 dirhams. And of that, your lordship assessed that figure at 60,000. So there is still those costs hung over from the last hearing. And if your lordship followed the same approach, there would be 60,000 dirhams up to the 7th of September. And then on top of that is this schedule of costs, which is 117,000 dirhams. And again, we ask your lordship to assess that and then add that to the 60,000.
Okay. Ms. Martin, have you points you want to take?
Yes, Your Honor. On extension of time, if the court would indulge me a couple of minutes to explain why we think these are disproportionate, I think it's helpful to walk through the math. So we would first start with the conclusion that half of the work last time really related to the individual defendants, which amounts to another 60,000 dirhams, as Mr. Shuji described it as the hangover from that hearing. And then now they have an additional 117,495 dirhams being claimed, meaning they have a total claim against the individuals of 177,495 dirhams when only 60,000 were awarded as to the corporate defendants. We believe this is excessive for a number of reasons. First, the majority of the evidence was put forward by the fourth defendant, and there has been some but very little new evidence ahead of this hearing. Mr. Berganza's third witness statement, produced by claimants, excluding the cover page, is 3 pages long. Only 3 paragraphs relate to the extension of time application, and evidence amounting to 4 total pages. It is difficult to see how this required a little more than 2 hours to put together, including supervision time. In the event that the court agrees to also include time for Berganza 4 or Mr. Iavine's proposed witness statement that didn't make it in evidence, which are almost identical in form and substance, this would not have required significant time for the preparation of either of them because the witness statement is 1 page long. Now, the extension of time hearing for the 4th defendant was estimated at 2 hours compared to 1 hour in this statement of cost, and the extension of time hearing on 7 September did not even last 1 hour of time, and as such, the 60,000 dirhams being claimed from the previous hearing, this already accounts for the time spent for preparation and attendance at this hearing, meaning we see this as double dipping here. Now, taking the cost for counsel separately, for the previous hearing, the total was 71,646 dirhams, for which the claimants were awarded total costs, and counsel's costs were 46% of the total claimed of the 60,000 awarded. In other words, 27,840 dirhams. This means the claimants are claiming an additional 27,000 on top of the 54 being claimed for today's hearing, and the total claim for counsel is 79,294. This is more than the total claimed in the last hearing, and that is unreasonable in our view because there are no new legal authorities provided by the claimants. The skeleton argument is in large part just a copy paste of the previous skeleton argument with paragraph numbers lining up number for number. And the only additional response is limited to the new several paragraphs of factual evidence provided. The overall amount claimed against the first and third defendant is 177,000 dirhams, as Mr. Shivji points out, but this is almost 3 times the amount awarded against the 4th defendant, and thus entirely disproportionate.
Can we just have a look at this bill, Ms. Martin?
Yes.
Looking at page 6738 and 6739 in particular, to see where the time has been spent, where the work has been done. So I understand your point about the totals, but if you were to be looking at the individual elements of it, where do you say the excess? I assume you're not saying that the time hasn't been spent, but where do you say the excess time is?
Well, there's over 15 hours attributed to work on documents, and what
Yes.
documents where there was only very little evidence, new evidence put forward, and it was all Swiss law opinion evidence.
Yeah. Anywhere else?
Well, we're just wondering why the considerable time from counsel's chambers as well, given, again, it was significantly a repetition of the prior skeleton argument. No new cases were put forward. If half of their work last time really attributed to their ability to perform their duties here, then what exactly is all this new time other than attendance to the hearing? one final point, Your Honor, is that we did all of the bundling for this hearing, even though it was the claimant's application, and that saved them some time and should count against them.
Yeah, all right. So are you putting forward a figure?
Well, 60,000 for last time, because the court already ordered that. We certainly think that the amount for this time should be no more than that, and we would say half of that amount, so 30,000, so a total of 90,000 dirhams.
Yeah, Mr. Shivji.
My lord, since the last hearing, around 1,800 documents have been put into the bundle to cover both jurisdiction and extension of time. We've tried to spare your lordship at the hearing all of the detail that the parties have gone to in the recent weeks since the 7th of September on both extension of time and jurisdiction. But your lordship can see from the way that this case is litigated that at the moment not much is done by cooperation. And just to give you some examples, in the extension of time, the way that those power of attorneys emerged was highly unsatisfactory, and that required numerous rounds of evidence in Swiss law advice about what the rules were on powers of attorney. And even when we eventually got the LNS power of attorney and then wanted to put evidence on that late production of documents, the defendants objected to it. So then it had to go into a supplemental objected to bundle. And all of these steps that worked on documents, putting together exhibits, obtaining translations, obtaining Swiss law assistance, all of that cost time and money. And although it's a pretty crude guide, your lordship can see from the fact that the bundle has gone up in size by nearly 50%, that a very substantial amount of work and analysis needs to be done to prepare for this hearing. And my learned friend has chosen to take a whole host of points on extension of time, all of which I needed to be prepared to deal with today orally. Now, the hearing has happily gone shorter than it could have done, but your lordship would have been in your rights to ask us any questions on any of the material that she asked for, and I needed to be prepared for dealing with that. And your lordship will know from your own time as an advocate that actually every hearing you come up to, you still have to prepare properly and thoroughly for, and there is always a limit to how much you can simply rest on your laurels from work previously done. So that is time that it obviously has been spent. The liquidator has no interest in incurring unnecessary costs because the estate has to pick it up. But we say these have been heavy applications. And of course, we have no visibility on what D4 is paying on the individual defendant side, because of course it's D4 who's picking up the tab for those defendants, not us. But we don't know because the individual defendants haven't submitted a cost schedule. One can see the hourly rates that they charge from their engagement letter, none of that suggests that their work is being done any cheaper than ours. And I haven't heard from my learned friend any submission that their costs are significantly less than ours. So in those circumstances, we say that ours were reasonable and certainly in the right ballpark, and it's not in the individual defendant's mouth now to say that we've overdone it.
May I respond to 2 points, Your Honor?
Yes. Are we still just talking extension of time for the moment, costs?
So far, yes.
Yes, very good. Go on.
To the extent Mr. Shivji again tries to make this about the conduct of the defendants, when the claimants proposed putting the powers of attorney into evidence, we asked them if they were providing translations. At that point, they backed off and said, no, they no longer need to be in evidence. So it's not that we protested them being in evidence. It's just that they didn't provide the translations for them to be put into evidence. And as for the estate needing to bear the funding costs, they have a litigation funder. So, you know, I don't purport to know what Mr. Hayter in giving instructions, what his motivations are in terms of the spend of attorney time. In our view, there's a lot of really unnecessary correspondence going back and forth, which makes it significantly more expensive and is certainly baked into what they're claiming for costs here.
All right, well, dealing just with the extension of time for the moment, I'm very conscious that this is hard-fought litigation with no court or offered. It seems to me that there's the additional 60,000, and as my understanding is that the claim for 117,495 is on top of that in its entirety. Is that right, Mr. Shivji?
Yes, it is, my lord.
Yeah, well, you can have 82,000 of that, so that's 142,000, so to speak, all told. Yeah, dirhams, of course.
I'm grateful, my lord.
All right, so that's 142. Then we're now going to deal with the costs of the jurisdiction. Ms. Martin, do you want to address me on that?
If I may. Our objections relate to what we consider to be the excessive amount claimed, given that this is in comparison to the last hearing. Again, very small and no significant work has been performed by them, including because when you look at their skeleton argument, they didn't even address the Liz Pendens argument. We also question why Mr. Neighbor seems to be performing the vast majority of the work at his billing rate rather than appropriately leveraging the assistance of the junior attorneys. He's significantly more expensive. The junior attorneys did the drafting last time, so it's unclear why he's doing almost all of it here. And that unnecessarily is driving up the cost of the bills.
Shivji?
Just on the involvement of Mr. Neighbor, he is one of the linchpins on our team. Often a criticism of law firms is that they have too many people on a matter, but as your lordship knows, there is a significant saving when one individual is very well briefed in the matter and across the relevant issues. So we say we've organised our team sensibly. Of course, again, we don't have any visibility of what was happening on the individual defendant's side. So it's very difficult, we say, for them to throw stones when they're not disclosing what their own approach was. It's quite unfair to say that this was having tried to persuade your lordship that things had moved on since the last hearing, as my learned friend did in submissions, and that in particular there was a whole host of new factual evidence that would cause your lordship to change assessment. It isn't right when it comes to costs for the defendants then to say, well, it was all the same and no new work was required. And it seems to us it's evident that there was a lot of work to be done. Your lordship will know that Devonish 6 in particular was an extensive piece of evidence, lots of new exhibits and allegations about where particular activities took place. For the purposes of this application, we had to then examine those questions to decide what we would put in evidence on. It becomes sorry, I haven't finished. It very quickly snowballs into heavy litigation, and the stakes are very high for the liquidator because, of course, he needs to make sure that these claims are brought in the appropriate jurisdiction. So we say that this is all within the reasonable realm, and that there's no reason to discount the cost in the way that the defendants say.
Mr. Shiji's statements are unfortunately impeached by the schedule that they put forward. The attendance on opponents category only totals 4 hours of Mr. Neighbor's time, where there's attendance on others totaling 13 hours. That plainly doesn't sound like it relates in any way to any response to evidence. And again, this is in comparison to the last schedule, which I'm not sure made it into the bundle, but the last schedule of costs that they put forward, for the sake of comparison, work done on documents, they had Mr. Neighbor doing 10 hours and 47 hours done by Ms. Hook. We would submit that that's a more appropriate allocation of responsibilities amongst the team. And whilst whether or not we considered that these arguments required additional work, it's plain that the claimants didn't consider they required additional work, because they largely, again, repeated their arguments from the prior skeleton arguments, and in relation to Liz Pendens really didn't address it at all.
Right. Well, all the material had to be gone through again, and with additional material, I consider the right figure here is 210,000. All right. Is that it?
It is from my perspective, my lord. Thank you, and I'm sorry you ended up sitting late, but I'm grateful for your time as always.
I don't think I'm sitting late, am I?
Oh, you're not? Well, I was told that we might finish by 11 UK time, but maybe that was optimistic.
I don't know what time was actually set aside for this, but anyway, there we are. That's fine. All right. Well, can you draw up the order and seek to agree it with Ms. Martin, and then let me have an agreed form of order for my approval. Send that to the court; they'll sort that out. And if there's to be an approved transcript of the judgment, again, it would be of assistance if that came sooner rather than later, because if it comes in a week's time, I shall have forgotten what I've said, and obviously it's easier to correct grammatical mistakes if one has some recollection of what it was one was trying to say at the time.
My lord, we'll get straight on that.
Yes, well, it'll be out of your control in part, but do what you can.
Thank you, Your Honor. I would note that we've also requested a copy of the transcript, and we were told that the transcriptionist cannot produce it for 4 business days. So I think that puts us next week for the transcriptionist copy of it.
Right. Is that what they tell you normally, 4 business days?
We always ask for overnight turnaround, and generally it's something closer to 4 days to a week.
Right. Yes. Well, I'm just interested to know that. That's slow, isn't it?
It put us in quite a scramble for the appeal. I do have to say that we found it very inconvenient. We weren't sure if we would be granted leave, and so we didn't want to waste the time seeking it. But it was we could have done with more time with the transcript.
Yeah. All right. Okay. Well, that's fine. If you wouldn't mind just signing out, I'll have a quick word with the associate, if I may. Thank you very much indeed.